And you understand there's an agreement that if you are eligible, you would be sentenced under 7411. Is that your understanding?
What is 7411?
It means that if you
This courtroom session starts casually, but something feels off. David Beyer's status suddenly shifts, and even the attorneys seem caught off guard. A routine hearing is quickly turning into a developing situation with real consequences. Stay tuned as this unfolds fast, and subscribe for more intense courtroom breakdowns like this one.
Hi, I have somebody on a Zoom device that just says Zoom user. If you could unmute so I could get your name, please.
Nathan Lawrence.
All right, I am going to rename you. Rhonda Underwood is your attorney, so I'm going to put her initials after your name.
Okay.
Miss Underwood typically goes back and forth and does usually go to Judge Olsavers first. So
Yes,
I will let her know only because I have the AG here on yours as well. Miss Brenner, I don't know if you have her cell phone number to text. If you want
I just had a
text her.
case in Olsaver with her. I think we had the only one, so she should be here momentarily.
Well, she might have more with him. I don't know. So
I don't think I'll text her though.
Okay. And let's see. Miss Brenner, I see that the notebook is coming to the Wharton Center.
Yeah, I wonder how that'll be. There's a bunch of them coming, but I've seen a lot of them.
Yeah, November. My spawn lost her mind and said, "We must go." I'm like, okay.
What's the one right now that's there? I wanted to go see that one.
And Juliet, maybe. Hi, this is Judge Anzalone. I am ready for David Beyer.
David Beyer, yes, ma'am.
All right, thank you.
Of course.
Bye.
Bye-bye.
All right, Mr. Goldstein, I just called for Mr. Beyer.
Your Honor, I was not aware that he was in custody.
Well, he's also, oh, yeah, he actually, though, is being arraigned in district court. Is that the one? Yeah, he's being arraigned in district court on a larceny charge at 9:30 today.
David Beyer? The same David Beyer?
It says David Michael Beyer. Yeah, he must be because he's in jail for me.
No, he wasn't in jail for you as of yesterday. I spoke to him.
It's on the jail list. I don't know. Let me see.
He's in holding, so he could have got arrested yesterday.
Oh, he's in holding, so he probably got arrested yesterday.
Okay.
All right. Danny, it's not in my waiting room, so.
So are they going to bring him for you now, since he's in the building?
I just called the jail for him. Yeah.
Okay. All right. When we get him, Your Honor, I'd like to have a breakout because this is all new to me.
Of course, of course. The arresting agency was, let me pull it up. Got my little list here. Oh, it doesn't say. Did you get arrested the day before? Let me go back a day. I don't know if I have my jail list from the day before. Let me see if I can find it. I think Doug's looking.
No, I don't have access to
Oh, so yesterday.
He wasn't on yesterday's.
Huh?
He was not on yesterday's.
Yeah.
So.
Do now. I'm sure he'll be able to tell you.
Okay. Well, I'll go ahead and turn and wait, and hopefully he'll be soon. So I'll just go back and turn my camera off.
I can call downstairs to the jail 2346. Okay. Hey, this is Judge Anslone. I have a question. I showed David Beyer is in custody. I called upstairs and they got him for me, but when was he arrested? And by who?
So he was brought in by the sheriff's department.
Yesterday?
Yesterday morning, I believe it was.
All right, so he wasn't on the new arrest list. That's why I was wondering. He was on arraignment for district court, but not the new arrest sheet.
Yeah, he's a weird one. He was already in our system.
Oh, okay.
Because he was like in a rehab program. So
Okay.
in that alternative housing, and then he came back.
Okay, thank you.
Here.
You too, bye. All right, David Goldstein, it looks like the sheriff's department brought him in yesterday. So.
That's interesting because, like I said, I spoke to him yesterday and I got confirmation of his treatment in rehab.
Dave or Darren, I got a letter from you that you didn't have confirmation, but.
I have that, which I can forward to Mr. Coast.
Yeah. All right, Mr. Beyer.
Hi, how are you this morning?
Good. Let me call your case and then I'm going to give you a breakout room. This is in the matter of the people of the state of Michigan versus David Michael Beyer II, file number 26-22537FH. I have David Goldstein appearing on behalf of Mr. Beyer, and I have Isaac Sneed appearing on behalf of the people. So I'm going to open up a breakout room for you to have a moment to speak with Mr. Goldstein so he can get an update. Okay. And when you're done, either come back or I'll bring you back if you don't know how. It's not a big deal.
Okay, thank you.
Yep. Here you go.
Please rise for court style session.
All right, Mr. Goldstein. We are back on the record with Mr. Beyer. So, Mr. Goldstein, you had enough time to speak with Mr. Beyer?
Yes, I have, Your Honor, and I'm trying to, we have an arrangement worked out in this matter. I'm trying to send back the plea sheet, but basically the offer is that he pleads to count 1, count 2 will be dismissed, and no objection to sentencing under section 7411 if he's eligible.
Okay, is that correct, Mr. Sneed?
Yeah, I'm bringing up the plea form now. I don't know if that's in the court's possession.
No,
No.
It wouldn't be because I'm just sending it. I'm trying to send it now.
All right, while I'm waiting for that, I'm gonna take care of Miss Brenner so she can scoot. It'll just be 1 second, and I can't remember which one it was. Oh, Lawrence. Let me bring in Mr. Lawrence.
This courtroom session starts casually, but something feels off. David Beyer's status suddenly shifts, and even the attorneys seem caught off guard. A routine hearing is quickly turning into a developing situation with real consequences. Stay tuned as this unfolds fast, and subscribe for more intense courtroom breakdowns like this one.
Mr. Lawrence, can you hear me?
Yes, ma'am.
Good. This is in the matter of the people of the state of Michigan versus Nathan Edward Lawrence, file number 25-22395FH. I have Rhonda Underwood appearing on behalf of Mr. Lawrence, and I have Sarah Brenner appearing on behalf of the Attorney General's office. This is the date and time set for a pretrial. Ms. Underwood, update or what would you like to do today?
Your Honor, if I could just speak to Mr. Lawrence for a second.
Yep, I'm gonna open up a breakout room and
yes, who's gonna be handling it?
I'm gonna put Mr. Lawrence and Miss Underwood in a breakout room. Do we have MDOC now?
Yeah, they just got here.
Good. And MDOC just got here on your other one, Miss Underwood. All right, so okay, everybody's busy this morning with search warrants. Okay. I'm waiting, Mr. Goldstein or Mr. Sneed. Let me know. Mr. Margosian. Yes.
Morning, Your Honor.
Hi, so I am ready in this order for
Okay.
James Neuenschwander.
Good pronunciation.
Well, I had someone help me. I have Daniel Norden
Okay,
and then William Byron.
and Byram, you will get them in that order, ma'am.
Okay, thank you. Bye.
Okay, Mr. Sneed, I just sent you the plea form.
Thank you.
All right, oh, must have missed that. Okay. This one's saying, oh, I did miss that, Miss Runner. Okay. All right, all right, Miss Underwood, let me bring Mr. Lawrence back. I do have Brian Osborne here. I do not have same, but okay. All right, so we're gonna go back on the record in the matter of the people of the state of Michigan versus Nathan Lawrence, 25-22395 FH. So Miss Underwood, you've had a chance to speak to Mr. Lawrence.
Yeah, Your Honor, Mr. Lawrence, I believe, is making $300 a month payments. He had some medical issues, so he's going to be able to goose that back up, I believe, in April, Your Honor. If the Attorney General's office has no objection, I would like to put this out to June 3rd, and Mr. Lawrence can continue payments, and I would be happy to do the stip with Ms. Brenner's permission.
Ms. Brenner?
I'm okay with that, Your Honor, but he should know he has multiple child support cases. So the money that he's paying is being split, and only a small portion of that $300 is making it to the case that he's charged on here. So just to make him aware of that, he paid $300, only 85 of it went towards this case.
Yeah, I plan on paying a lot more starting in April.
Okay, that's fine. I just wanted you to be aware.
And Mr. Lawrence doesn't live in Michigan, so he can't come here directly to make a payment. That would apply only to this case. Mr. Lawrence, do you have any family that lives in Michigan?
My mother does, yes.
She live in Lenawee County?
Yes.
So the only other option, if he wanted more to go specifically to this case, would maybe Venmo the money to your mom.
Okay.
Or wire transfer it and have her come pay the full amount here in person.
Okay.
Well, and Judge, they're both Lenawee County cases. So you're aware too.
But he doesn't have a felony. He's not being charged with a felony on both, right?
Correct. So his mom would have to be very specific when paying there at the FOC.
So Mr. Lawrence, if you did that, your mother would have to have this specific case file number.
Okay.
To pay it directly on this one, all right?
Yes, ma'am.
And Miss Brenner, can Miss Underwood sign your name with permission?
Yes, Your Honor.
All right, we will set this for pretrial on June 3rd of 2026 at 8:30 in the morning. All right, thank you, Mr. Lawrence.
Yeah.
Thank you, ma'am.
Thank you.
Bye.
All right. Hold on, Miss Underwood. I got Brian Osborne. I think that's going to be another adjournment.
I believe so, Your Honor.
Okay. And I do not have sane, but we'll address that. Mr. Osborne, unmute your device, please.
Hello?
Hello. All right, so Mr. Osborne, good. This is in the matter of the people of the state of Michigan versus Brian S. Osborne, file number 25-22344FH. of Brenda Underwood appearing on behalf of Mr. Osborne. I have Sarah Brenner appearing on behalf of the Attorney General's office. This is the date and time set for a pretrial conference in this matter. Ms. Underwood, how would you like to proceed today?
Your Honor, Mr. Osborne has sent me proof of a payment of, I'm sorry, how much was that for, Mr. Osborne?
It was a payment for $500.
Okay, that you made what date?
I made it yesterday.
Okay, great. And I do have a receipt for that, Your Honor. I talked to Ms. Brunner earlier. I believe this is, and Mr. Osborne also is waiting for a FOC date for a hearing demanding on his arrearage, Your Honor. So I would request another pretrial stip to adjourn to June 3rd, Your Honor. And I would be happy to do the stipulation with
Ms. Brenner?
No objection, Your Honor.
All right, we will adjourn this to a pretrial on June 3rd of 2026 at 8:30 in the morning. Mr. Osborne, you're all set. In the matter of
Thank you.
the people of the state of Michigan versus Clay DeCarl Sain, SAIN, file number 25-22345FH. This was set for pretrial today at 8:30 in the morning. It is 8:53 in the morning. Ms. Brenner, is he making payments? And I have Rhonda Underwood appearing on behalf of the defendant.
No, Your Honor. He stopped making payments in January.
Of this year?
Yeah, he had an income withholding order in place and then it stopped. So something's going on with him. Not sure what.
Okay. Ms. Underwood, have you had contact with Mr. Sain?
I attempted to have contact with Mr. Sain, Your Honor, but I have been unable to reach him.
All right, what is the arrearage owed on this, Ms. Brenner?
He currently owes $21,689.01.
At this stage, the focus shifts to financial compliance, and it's clear the court is tracking every dollar. Payments are being split across multiple obligations, weakening the defendant's position. This raises a key question. Can partial compliance ever truly satisfy the court, or does it only delay inevitable consequences in cases like this?
All right, I'm going to issue a bench warrant for his arrest, and I will set bond in the amount of $22,000 cash. Obviously, Ms. Underwood, I don't sign that for 48 hours. If you hear from Mr. Sain, I can take that away and set it for pretrial next week, but $22,000 cash bond.
Thank you.
We'll prepare
All
that,
right.
Judge. Thank you.
All right, thank you, Ms. Brenner. I believe that's all I have with you.
That is. Thank you. Have a good day.
All right, thank you. And who do I have in jail Zoom for?
James Newitschwander.
All right. All right, and Mr. Norton, I'm waiting for him, Ms. Underwood. Mr. Dagger Margosian, what are you going to be doing with Mr. Nunschwanger?
Your Honor, may I speak with him, please?
Sure. I'm gonna put you in a breakout room, and then I'm gonna go back, Mr. Goldstein, to your file. There we go. Join that breakout room. All right, Mr. Goldstein, I am back on Mr. Beyer, Mr. Sneed, in the matter of the people of the state of Michigan versus David Michael Beyer, file number 26-22537FH. Mr. Goldstein and Mr. Sneed, were you able to verify the plea offer?
Yes, we did, Your Honor. Thank you.
Okay, so it's to plead guilty to count 1 and then no objection to 7411 if he's eligible.
Correct.
Okay, all right. So Mr. Goldstein, is your client going to avail himself of a plea today?
Yes, Your Honor.
All right, Mr. Beyer, raise your right hand for me, please. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, Mr. Beyer, you have heard the statement of your attorney, the prosecuting attorney, and myself. Is it your intention today to plead guilty to count 1, controlled substances, possession of cocaine less than 25 grams, which carries a maximum penalty of up to 4 years in prison and or a $25,000 fine?
I do.
And you understand there's an agreement that if you are eligible, you would be sentenced under 7411. Is that your understanding?
What is 7411?
First
It means
offender
that if
pro-
you,
Sorry,
oh,
Judge.
go ahead, Mr. Goldstein.
That's the first offender program, Mr. Beyer, so that if you successfully complete probation, you have no record.
Okay, yeah.
And
Understand.
it also does not interfere with your driver's license.
Okay, I understand.
Okay, and then count 2 would be dismissed. Do you understand that?
Yes, ma'am.
All right, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any other possible sentence with the court. Mr. Goldstein, is that correct?
Yes, it is, Your Honor.
And Mr. Sneed?
Yes, Your Honor.
And Mr. Beyer, is that correct? So there's been no discussion about probation terms or any jail sentence?
Correct.
Okay. If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial, to have witnesses against you appear at trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you have the right to testify at your trial if you want to testify. Do you understand if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
I understand.
Do you understand that any appeal from this conviction and sentence pursuant to a plea would be by application for leave to appeal and not by right? Do you understand that?
I understand.
This is a turning point. Non-payment and lack of communication just triggered a bench warrant. The court isn't guessing anymore. It's acting. A $22,000 cash bond sends a strong message. When defendants disappear or fall behind, patience runs out fast. This moment shows exactly how quickly situations escalate in courtrooms like this.
Do you understand that if your plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea. Misconduct is defined to include, but is not limited to, absconding or failing to appear for sentencing, violating terms of conditions on bond or the term of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentence. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No, Your Honor.
Mr. Beyer, how do you wish to plead to the charge that on or about September 9 of 2025 in the city of Adrian in the county of Lenawee that you did commit the offense of possession of cocaine less than 25 grams? Guilty or not guilty?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, Your Honor.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, Your Honor.
Okay. Has your attorney promised you any other particular sentence or estimated what your sentence will be?
No.
Is it your own choice to plead guilty?
Yes, Your Honor.
All right, so Mr. Beyer, on September 9 of 2025, were you in the city of Adrian in the county of Lenawee?
Yes, I was.
And did you have in your possession cocaine in an amount less than 25 grams?
I did.
Did you have any legal right to possess that cocaine?
No, Your Honor.
And you knew it was cocaine?
I did.
Are you satisfied, Mr. Steen?
I am. Thank you, Your Honor.
All right, has the court complied with MCR 6.302 B, C, and D? Mr. Goldstein?
Yes, Your Honor.
Mr. Steen?
Yes, Your Honor.
I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I am going to refer this matter to the probation department for a pre-sentence investigation. There is a Let me see here. There is a contempt of court that has been following this file since district court. I'm going to continue that to sentencing, and if there's no further violations, I will dismiss the contempt. All right.
Okay.
And Mr. Goldstein, are you available to do sentencing on April 24 at 8:15 in the morning?
Yes, Your Honor.
All right, so Mr. Beyer, I'm going to set this for sentencing on April 24 at 8:15 in the morning. Now, Mr. Beyer, Mr. Goldstein is not being held on my file, is that correct?
That's correct, Your Honor.
And do you want me to give him a bond so that he's getting some credit, or do you want me to leave it as it is in case he gets released on the other file?
I anticipate a PR bond on this other matter, Your Honor, so I'm asking that you leave the bond where it is.
Okay, so Mr. Beyer, in the event you don't get released for whatever reason, Mr. Goldstein will reach out and I can change our bond to a you know, some type of cash surety bond so that you're getting credit, okay? But otherwise, I'm gonna leave you on the bond we have. Mr. Stevenson, would you like a quick breakout room with Mr. Beyer to get his contact information?
Yes, I would.
All right, so Mr. Beyer, understand that upon your release from the jail, you need to report to the third floor probation department to pick up a packet to fill out and set up a time to meet with the probation department. Failure to do so can result in a bench warrant. Do you understand?
Okay, so I get released from the jail today, depending on my other case. Right?
Well, if you get released by Judge Morgan on the other case, you have to go into the probation department yourself. If for any reason you don't get released, I'll let Mr. Stevenson know and he'll come see you at the jail.
Okay. So
If you're out,
I'm sorry.
hold on. If you're out of jail and you meet with them, make sure that you're, or if you're in jail, be truthful with them about your background, the events that occurred. They'll prepare a pre-sentence report. We'll provide a copy to Mr. Goldstein, who will review that with you. And then we'll see you back for sentencing on on April
24.
And Judge, if he's
15.
released prior to sentencing, he does have a testing requirement where he's required to test 1 time a week. So he would also need to see me to set that up.
And when you check in at probation, you can ask the clerk's office for Mr. Coast. His office is on the 3rd floor as well. So you need to see both of those when you get out of jail. But do you want to appear for sentencing via Zoom or in person?
By Zoom, Your Honor.
Yeah.
Zoom okay, Mr. Beyer?
Yes, ma'am. Yes, Your Honor.
Okay. You can also come in person if you need to, but all right. Thank you, Mr. Beyer. You're all set. Thank you, Mr. Goldstein.
Thank you, Your Honor. I'll see you.
Now, the judge carefully walks through rights, making sure Beyer understands exactly what he's giving up. This isn't just procedure. It's protection against future appeals. Every yes locks him deeper into this plea. The system slows down here for a reason, because once accepted, there's no easy way to undo this decision.